I want to welcome everybody. I am Joey Gartner. I'm the staff counsel for the ABA Task Force on Law and Artificial Intelligence, and welcome to today's webinar, Artificial Intelligence, Law Schools, and Access to Justice. Today's conversation is brought to you by the Presidential Task Force on Law and Artificial Intelligence, and its two working groups, its working group on AI and legal education, and its working group on AI and access to justice. The views of today's speakers may not represent those of the ABA and have not been approved by the House of Delegates or the Board of Governors. The opinions of our panelists may also not represent those of their employers. As a few housekeeping issues this morning, we'll have the question and answer function turned on, so please feel free to post any questions in the live Q&A for our panelists. We'll also have live transcription for today's event, which has been enabled. As time allows, panelists may answer your questions live throughout the panel today. We've got a truly great event today looking at AI, legal education, and access to justice. And moderating our panel today is Jim Sandman. Jim Sandman is the vice chair of the ABA Task Force on Law and Artificial Intelligence. He's a distinguished lecturer and senior consultant to the Future of the Profession Initiative at the University of Pennsylvania Carey School of Law. And he is the president emeritus of the Legal Services Corporation, the United States' largest funder of civil legal aid. Jim, welcome.
Thank you, Joey. Good afternoon, everyone. We have an all-star of legal educators who are leaders in both technology and access to justice. Margare Hagan is director of the Legal Design Lab at Stanford Law School. She is a nationally acclaimed leader in using design thinking to improve the accessibility of legal services. Dan Linna is professor of law and director of law and technology initiatives at the Northwestern University Pritzker School of Law and the McCormick School of Engineering. He develops innovative ways to use technology in legal education to prepare students for modern legal practice. Gabe Teninbaum is Assistant Dean of Innovation, Strategic Initiatives, and Distance Education at Suffolk University Law School, where he is also professor of legal writing. Gabe focuses on teaching students how to use technology to deliver legal services more efficiently and affordably. I'd like to start by asking each of our panelists to give an overview of course and clinical offerings at your law schools about the subject of technology, innovation, and access to justice. Could you give us a sense of the subjects that you cover, the number of courses that you offer, what the level of student interest is in these subjects? And I'm particularly interested in hearing about the extent to which, if at all, instruction in technology, innovation, and access to justice is mandatory in any part of your curriculum. Let's start with Margaret.
Hi, everyone. Thank you, Jim, and great to be here. So at Stanford Law School, we are rapidly expanding the amount of courses, especially hands-on practical courses, that are at this intersection of access to justice and technology. Obviously, this has been a hot topic for several decades now. And we have courses in our ethics track required of students, as well as new kind of optional seminar courses like access to justice, that as part of that overall discussion about the justice crisis in the US and ways to address it, technology is a consistent theme, and there's discussion about the landscape, issues, and ways to improve it. Increasingly, though, we've been offering more hands-on classes. Sometimes we call those policy labs, in which we partner with groups like the American Bar Association's Free Legal Answers or the Legal Services Corporation's TIG team to deal with kind of frontline practitioners' issues at this intersection and have students kind of with practical projects think about new solutions, whether they're technology solutions, policy, improved services, that they can see through kind of hands-on applied in a local jurisdiction or a local context, how A2J and tech issues emerge. And with the new wave of generative AI, I would say there's a lot of increased interest, both from students who traditionally would be very interested in tech and tech law, about how this new wave of technology might apply to different areas of the legal system, including the justice gap, and students coming more from the public interest side, who have heard about AI are thinking the same way. Is this a big new solution? So we've been innovating new courses to tackle this particular intersection of generative AI and access to justice. But I'll stop there. We can talk more about that in a second.
Jim, I think you're muted.
And this is a webinar on technology. Thank you, Dan. Margaret, you mentioned that in your mandatory ethics course, there is some training about access to justice. Does it include technology? And is everybody required to take an ethics course that includes that component?
I can't speak to that because there are different versions of classes that meet the ethics requirement, but I would say increasingly so. And I know as a student myself, though that's a decade or 11 years ago when I had my required ethics course, and Professor Deborah Rohde was the teacher. A large part of it was on access to justice as it relates to ethics in the legal profession. And a slice of that access to justice section is about technology. So I wouldn't say that there's an access to justice and technology required course, but hopefully more and more students are getting exposed to that intersection.
Thank you. Dan, what about Northwestern?
Yeah, so we've at Northwestern for a while, we've had deans who are really thinking about this intersection, Dan Rodriguez, and now our current dean, Hari Osofsky. And so we've been increasing our courses and co-curricular activities in this space for a while. I've been teaching AI and legal reasoning now for almost a decade. I taught at the University of Michigan and at Michigan State, and I've been teaching at Northwestern. It'll be my 7th year of teaching it. And there's been very strong interest in that course from the first offering. Now it's a smaller course. It's a 25 student lecture course. But it's been filled, and we have great interest in that course. I also teach a class on law of AI and robotics, and that's more focusing on regulation and the law of AI. But we absolutely also talk a little bit about practice and how it's going to change the role of the lawyer and access to justice, courts, things like that. And then we have an innovation lab course, and I co-teach that with my colleague in computer science, Chris Hammond, who has decades of experience in AI, both practical, building companies, and as an academic researcher. We have teams of computer science students and law students. They work in interdisciplinary teams, and we do projects. We do projects with large law firms and companies, with legal aid organizations and courts. And one of the things that I would love to see more of in this space is we tend to kind of silo access to justice and innovation in corporate legal departments and in law firms. But it turns out legal services delivery challenges are a lot more similar than they are different. I think there's so much to learn at that intersection. And that's one of the things we really try to do in our innovation lab, is to get students thinking about, if you're in a corporate legal department or in a big law firm, the ways in which you might use technology there. How would that work in courts or legal aid organizations, or creating self-help tools for individuals as well? What can we learn across those spaces? And then another thing I'll mention is our Law and Technology Initiative. And that's a partnership between Pritzker School of Law and McCormick School of Engineering. And it's so wonderful to have this partnership with computer science, the engineering department. We've got students who come from the undergraduate school and from master's and PhD programs, and who are very interested in access to justice and how courts work and in law. We do academic conferences, workshops. We've done multiple workshops this last year, for example, on prompt engineering, training our students on that. The different academic conferences we host, some of them are just more traditional conferences. Some have been partnerships with student journals and things like that, which is a great way to get students engaged. Now, outside of my own classes in legal ethics, these topics, of course, come up. And Wendy Muchman is an example of one of our legal ethics instructors who very intentionally incorporates these tools into her classroom, including now ChatGPT, but I've co-authored papers with her in the past and thinking about technology and the ethics challenges around it. Michelle Falcoff oversees our legal writing program. She's been thinking very carefully about how to integrate this into the courses, especially since with the rise of ChatGPT, and I know in our contracts drafting classes. Now, to your question about the requirement of these classes aren't required. So if you're a student and you wanted to avoid all this stuff, you could probably find a way to avoid a lot of it. More and more, it's coming into classes in different ways, and it's an important part of the curriculum. But I think this is one of the things we really need to think through in law schools is, how important is this? And I think we'd all agree on this call, this is really important. And how do we make sure that the students are getting what they need, not only so they can be successful in their career, but so that we can all do the kind of things that we need to do to improve rule of law and improve access to justice.
Dan, you mentioned siloing, and you were referring to the separation of thinking about, say, corporate legal practice in an in-house legal department and legal services, a legal aid organization. And I see a lot of similarities between those two, actually. In a very large corporation, it isn't possible for the legal department to provide one-on-one service to everyone. You can have hundreds of thousands of employees who are dependent on you, and you have to figure out ways to serve them efficiently and to enable self-help, just like legal aid. But there's another aspect of siloing that you alluded to, and that is law can be pretty insular and not very interdisciplinary. You mentioned computer science students in your classes. Are there other examples of ways in which you reach across the university to include other disciplines in the way you're educating law students?
Yeah, well, one other thing I should mention is we have a Master of Science in Law program, and that is a very interdisciplinary program as well. And these are not students who want to get a JD. They're interested in learning some things about law. For some of them, that's they're in medicine or in a company as part of product development teams. So they want to learn a little bit about compliance and regulation. And more of those students are coming into our program and then going into a legal operations role, or taking my innovation lab class and then getting involved in legal aid programs and things like that. Teach some classes for computer science students, Introduction to Law and Digital Technologies, Law and Governance of Artificial Intelligence. And of course, the intersection of computer science and law, I think, is really interesting because it's bi-directional. Law is going to have an impact on how computation and AI is used in the world, and computation and AI is going to have a big impact on how we deliver legal services, how courts operate. But of course, there are many other disciplines, and one could argue all other disciplines need to be a part of this conversation as AI continues to affect the world. And one other thing I'll just mention here is that there's sometimes resistance among faculty and even lawyers about interdisciplinary education or doing a class like this with computer science students. And they think, well, our students don't need to be machine learning engineers. They don't need to learn the program. And, I actually think it'd be good for our students to learn some of that. But the other thing they miss out on is it's so valuable to be part of a team and learn how to communicate with that team, learn how to develop a product together. And, they're developing these other human skills that have been long neglected in law school as well, which is going to be more and more important in future success inside of any type of organization.
Yes, and Margaret is a master of that. Her work is at the intersection of the Stanford Design School and the Stanford Law School. Gabe, tell us about what you're doing at Suffolk.
Jim, first, my gratitude for you moderating this event, the ABA for hosting, and importantly for the participants for taking time from their day to be here. It looks like we have a goodly number of people here to check this out. So Suffolk Law has been at this for some time. Our wonderful Dean, Andy Perlman, was the reporter for the ABA 2020 Commission, the folks that came up with the duty of tech competency. When he became dean, driving these concepts of innovation and technology into legal education became a key part of what he viewed as our mission. So Suffolk Law now has something like 25 different courses that are on legal innovation and technology. It varies by year and faculty interest. And the majority of our students have some interaction with at least some of the courses, which fall into three basic buckets. One are hands-on legal innovation and technology courses, where you might learn how to do document assembly or learn how to do prompt engineering using generative AI. The second group are these sort of Lean and Six Sigma process type courses. And the third are courses that are fundamentally about new mindsets for approaching legal work, new business models, new ways to think about the legal profession. Because if you have all the tools, but you don't know how to adjust your business model to incorporate them, you haven't solved the problem. Now, in terms of clinical education, we have what's called the Legal Innovation and Technology Lab, the LIT Lab, which is a lab that focuses on building access to justice solutions, largely for courts and other legal services organizations. And they've done remarkable things. We have 2 full-time staff members, Quentin Stainhouse and David Colarusso, who have been around the legal tech world forever, and they work with students to build solutions that largely help pro se litigants. And in the last couple of years, we've had something like 44,000 people that we've been able to assist using these technologies that we wouldn't have otherwise been able to reach. And then the one other thing that we do that's interesting in the clinical program is we have what are called LIT, Legal Innovation and Technology Fellows. And we have all of these traditional clinics that most law schools have, defenders clinics and eviction clinics and immigration clinics. And the question is, can we second some members of our legal innovation and technology team into these traditional clinics to make them more efficient and effective? So if you have a traditional immigration clinic and you're doing refugee asylee intake, the question is, can we help create a form that allows you to do a more efficient intake and collect data on the back end? So we every year run this program to embed our legal innovation and technology students into these other traditional clinics. Exciting stuff.
What do you all think about whether instruction in technology, innovation, and access to justice should be mandatory for all law students? Do you think that the average law student graduating from an American law school today has an adequate grounding in those subjects?
Well, I'll jump in. No, absolutely not. Not even close. The average law student does not. And so I think we need to think more about just even this duty of technological competence. I think there's going to be other things that are going to force change, and including the duty to only be able to charge reasonable fee, right? We've already seen that with electronic discovery, for example. If you were in a law firm and you put 10 people, junior associates on a document review project, the client would say, wait a second, what's going on here? And oh, by the way, I think you have an ethical obligation to use technology to charge me a reasonable fee. So I think we're going to see more and more pressure to change the way that legal services are delivered, and that's going to require that students have an understanding of these technologies. And I think there's huge opportunities for them if they have an understanding of these technologies. I will say requiring the courses, and that's a tricky thing, right? And because I think we need kind of like legal tech instruction 2.0, I think is like the next version of thinking what the curricula needs to look like. So we've had a lot of really cool experimentation across law schools. There's a handful of schools, not many, like Suffolk, that have really built out their curriculum around this. But I think we also have to think about how do we, just like in practice, how do we improve education, the rigor of the education, keep building it as a discipline? One of the great things about the explosion in generative AI activity is there's been an explosion in research being done in this space. So I think we've got more and more of a foundation to bring more rigor and discipline to this, both in practice and in how we educate students as well.
Margaret and Gabe, when you answer the question, would you also address whether and to what extent you think that these subjects can be adequately addressed after people graduate in the workplace, which is the traditional way that new lawyers have learned practice readiness?
I'm happy to take a pass at that. So I'm going to go to the first part of your question first, Jim. I think the duty of technological competence is a serious thing. And if we're to do our job, students have to graduate ready to meet that. So that means that they have to have an understanding of the benefits and risks of technology that's relevant to their future areas of law practice. So that, to me, is the baseline, the level that even a school that finds themselves relatively disinterested in these topics needs to meet to meet the basic threshold of obligation. Now, the intersection with pro bono is a really interesting one, because what better way to get students into the flow of doing pro bono than to teach them to use tools to do pro bono at scale? So Suffolk Law School, as I suspect Northwestern's and Stanford do, have wonderful offices that connect students with pro bono opportunities. One of the things that we do is we try to find that nexus. We try to find opportunities for students to have internships or other working opportunities where they can go, they can do legal aid work, they can do access to justice work, and they can use technology along their way. Now, it's a bigger trick to do it for practicing lawyers. The most common thing that I hear when I talk about our work at Suffolk Law and legal innovation and technology, and I suspect the other panelists do too, is from practicing lawyers that say, how can I do that? That ship has sailed for me. I've graduated. There aren't enough effective CLEs. So there's some interesting organizations that are out there that do things like connect lawyers that are interested in pro bono work with projects that also teach them legal innovation and technology skills. And then there's also some really cool methods and technologies out there that someone can learn as part of a pro bono project and then actually bring back to their practice after they've taken part of the opportunity. And I think actually one of the things that we should all model is the sort of work that the Stanford Legal Design Lab has done in teaching people these sort of concepts that they can apply to a pro bono project and then take back into the rest of the work. Margaret, sorry if that's stepping on your toes, but I had to say that because it's a really good example.
No, that's great. And I mean, I expect that if we are kind of in the transition stage right now, both from the point of view of law students needing to know what skills do I actually need to have a great career in this new era, law firms struggling with kind of how they're going to staff projects, deploy AI, what the future of young kind of lawyers and career development, professional development are, and law schools trying to get there. Obviously, we're in a transitional stage right now. I just remember an event that was probably last autumn, so a good 6 months ago, with people from kind of junior associates at a major Silicon Valley law firm at a lunchtime event, packed auditorium of law students trying to understand what this brave new reality is going to be and what the life of a young associate is actually like, how much AI, what kinds of AI, what the law firm is going to be providing when it comes to training, what they should be getting at law school. So we're kind of in a dance right now, but I think the law students are really keen. If there is going to be a new way of practicing, they want to learn it. Even if they are going to go to a more corporate career. And that kind of loops me back to what Dan had been mentioning earlier about how these traditional silos of corporate lawyers and their tech separate from public interest lawyering and work in their technology, where I think there's a huge opportunity. Obviously, corporate legal tech has a lot more resources, many more vendors, many more use cases and case studies, whereas in the public interest space, there still is a lot of interest from legal aid lawyers and court help. But without that kind of money, capital, and technology infrastructure, we just don't see quick deployment of new tech projects. There's a lot of learning and mutual learning that can be happening in practice, whether it's called pro bono or something else, as these new AI groups and kind of new kinds of professionals are developing in corporate legal, how we can pair that with public interest groups so that those learnings, that technology, the best practices, those ways of working can spread organically across. I'm hoping that that's a future that will be happening so that we don't end up with two very different kinds of legal technology ecosystems.
I want to drill down on one aspect of potential mandatory instruction, and that's instruction in the use of generative AI. Do you think that that should be mandatory for law students today? What are your views on law schools or law professors who have prohibited or limited the use of generative AI? I'm thinking about the incoming class of law students this fall. They'll be starting in the fall of 2024, and they're going to graduate in the spring of 2027. In the world of generative AI evolution, that is huge. And I worry that they won't be prepared for the world they're going to graduate into if we don't do something, probably in the first year, in the legal skills or legal writing course, whatever the law school calls it, to get them up to speed. Let's start with the professor of legal writing. Gabe?
I'm going to broaden my response. I think it's incumbent on all knowledge workers, not just legal knowledge workers, to have a fundamental understanding of generative AI. We've seen the Goldman Sachs reports and others that say this is going to upend everything. Where using your noodle to make a living is key because it does a lot of things that people get paid to do much more efficiently and in some instances just as effectively. So starting year one, right after these products got released, we started introducing this into our legal practice skills course, which is our first year legal writing class. This past year, my wonderful colleague Diane O'Leary ran a generative AI course that taught students more sophisticated skills. I think that this must be a continuing part of everything that we do. And the reality is, and I'm stealing this without attribution, is that the future isn't, ChatGPT versus lawyer. It's lawyer that understands ChatGPT and competitors versus lawyer who doesn't. In other words, it's not going to be an option to use these tools. It's just a matter of whether you are able to harness them effectively. So I think we have to introduce it anywhere and everywhere, starting on day one of legal education and beyond.
I mean, we use generative AI in our classes as an exploratory tool to see if, so many of our classes are trying to understand the experience of normal people without lawyers who are having a legal problem like a debt collection lawsuit or an eviction notice. So we have students go on not to draft their final papers submitted to us, not to do what they are going to be graded on for the course. We keep that, like, that is not for them to be using generative AI to be producing the memos, the papers, the analysis. But we want them hands-on in the classroom to be trying these out, seeing the dynamics, learning how to be responsible when it comes to algorithmic, like interacting with algorithms and AI, and also to see for themselves firsthand the risks and the benefits. So many of our law students go in incredibly skeptical of AI, thinking it is going to be garbage in, garbage out, all junk, all hallucinations. But as they interact with it and as they do user testing with it, they can see that in some cases there is value, even if it's not, giving a full-on legal memo. They can start to appreciate how to use this, how to extract value, and why other people around them are going to be using it. So it kind of takes the AI, which for many law students, after those headlines of career-ending hallucinations, have tried to wall themselves off from it. So I think as instructors, as law schools, need to have, a strategic plan that we want our students exposed to it. We know they're going to be getting prompt engineering training from many of the law firms they're going to be placed in. Like, AI is definitely going to be part of their practice. We want them to be literate, to kind of understand. We know that landscape is going to be changing, but we just have to be doing this in a really responsible way and still being able to evaluate their reading, writing, research, and other kind of lawyerly skills apart from their use of AI. I still think there's a lot of value in having them do a lot of that work product without using AI while still educating them in it.
Thank you. Dan?
Yeah, I wholeheartedly agree with nearly everything that was just said. And I think that it has to start day one, training students to use AI tools responsibly and use them well. I wouldn't prohibit them for anything. And I think it's a mistake that we are prohibiting the use of these tools for anything. I think you need to learn to use them. This sounds to me like it feels like back when I went to law school and the debate was the books versus using online computer research. And, my professors were convinced I'd never be successful if I didn't know how to shepherdize cases, and use the pocket parts in the back. And it turns out that that wasn't the case just a few years later. So I think professors really need to think, if they're worried that students are going to cheat by using one of these tools, well, then I think they probably don't understand the tools very well, and they need to think about how to redesign their assignments. I'd love to see it introduced day one. These students go into internships after their first year, and they're going to be asked to or expected to use these tools. And so right away from the beginning, I think they need to think about, how do I use these tools responsibly in writing, whether I'm using a tool from Westlaw or Lexis, or even if I'm just using ChatGPT to help me brainstorm and create an outline and review my writing. So I think it has to be part of the workflow from day one. These are not elementary school students or junior high students. These are developed professionals already who are 22 to 30 something, or, and up years old already. One other thing I'd mention is that I'm a little worried about what the future looks like in some of these areas. So I generally agree that I think there's this lump of labor fallacy. I don't think we're necessarily going to have fewer lawyers, but there are law firms that are looking at this and saying, gee, we might need fewer junior attorneys, right? And they're trying to think about this. I think that's the wrong way to look at this. I think they need to think about how it's going to upskill everyone, and it needs to start in law school. We need to demonstrate. I was just on another corporate legal department program before this one, and they were talking about using generative AI, so a second year is performing at the level of a fifth year. Well, how's that going to happen if we aren't producing law students that are, performing, at a higher level to begin with? But I do think there's going to be some areas where it's going to really take 10 or more hours of work and turn it into 10 minutes. And I think we need to be thinking about, what is it we really do as lawyers, and how do we provide value to our clients, and what is it that we're going to do in addition and on top of that? And in some areas that might be obvious, but it may not be in a lot of other areas. So I think, there are a lot of reasons why our students need to be using these tools well and responsibly starting, immediately day one.
I'd like to respond to a question that's in the Q&A. What is your assessment of the potential of generative AI to improve access to justice? And what do you think the low-hanging fruit is right now? And specifically, could you give some examples of current use cases that demonstrate the benefits of generative AI for two audiences? One, lawyers and people who work with them, including legal aid organizations. How might they incorporate generative AI into their everyday work to improve their efficiency and serve more clients better? And second, what is your assessment of the utility of the current generative AI products for direct-to-consumer use, people who are accessing without going through a lawyer?
I can jump in. So I would, as I mentioned earlier, I think we are still very early days when it comes to real case studies or examples of generative AI deployed, let alone evaluated in most legal aid, court help centers, or other kind of access to justice service providers. That said, there's a lot of interest. We have led, with the help of the Self-Represented Litigation Network, workshops on all different kinds of ideas. At the ABA NLADA Equal Justice Conference, a room full of legal aid and court help lawyers full of ideas. There just is not the capital, resources, and kind of market of suppliers to build those as quickly as happens in corporate legal. That said, I think the near-term kind of safer use cases are a lot of the behind the scenes kind of use cases. So producing better guides, flyers, website content, improving plain language, making them more accessible and resonant and engaging. A lot of that kind of redrafting of the content that organizations put out there. So kind of safe, not advice, but improving information. Other use cases that I've seen are legal aid lawyers who then use AI that's common in corporate law firms to do first drafts of briefs, of discovery work, of kind of things that usually take them 40 minutes, reducing it to 5 minutes as a kind of drafting tool. Still lots of human review. They're not putting it in the hands of clients. I think all those cases of generative AI in the hands of either a client or a member of the public is kind of that next stage. So I think the kind of innovation model that a lot of groups are operating in is that they'll do AI behind the scenes, test it, see how it performs, and then gradually, if they can trust it and see good outcomes, seeing how much they might be able to put it kind of front stage in the hands of clients or members of the public. But we're still very early days. I don't know, Gabe, I know the Lit Lab at Suffolk is thinking about this a lot too.
If I may, I think Margaret's answer was perfect. The generative AI right now is ready for a business of law or behind the scenes functionality. So there have been a number of studies that say, for example, that generative AI tools are already as good or better than humans at summarizing complex documents. They're also very, very effective at searching through documents. So let's imagine that you're a busy legal aid attorney and you need to search through a long police report, or you need to search through a deposition transcript. Generative AI can find information, but not just find the words, not just find a regular expression word match. It can do things like find, tones. And it can identify pieces of information that you can copy paste or otherwise drop into a brief or a memo or a letter or something like that. What I think is next will be using these tools to help clients in simple ways. So you can imagine how courts have kiosks now that provide people basic legal information. Here's the courtroom you go or the office you go to for this type of service. Here are the types of things that it might be able to assist you with. They are not ready for legal advice, even if that was something that was legally permissible. I think technologically, I just wouldn't feel comfortable with it. But I'm confident that it will get there at some point in the near term.
I'll just jump in with a couple examples. A project that we have worked with in our innovation lab is Rentervention in Chicago. It's a chatbot. And this preceded this latest wave of generative AI. And it uses a mix of a rules-driven system and large language models. The first iteration was Google Dialogflow. You could put in a natural language description of your problem. It would categorize it into one of 8 different types of problems and then lead you down a workflow to gather the information through a rules-driven process and solve your problem. Help you draft a letter or do whatever it is you need to do. And I think that some of the discussion that we're having about the work that's being done in all of our innovation labs helps highlight that. I'm also a little bit concerned about where we're so now focused on generative AI, and we need to have a little bit broader of a lens. There are a lot of different AI tools. There are a lot of technology tools. Oh, and by the way, it's more like, I like to say, people, process, data, technology, right? So the solutions here are not going to just be generative AI. I think there are some tools that are, the legal research tools are pretty darn useful already, to be able to use techniques like, if you use ChatGPT, you're going to get hallucinated cases. It doesn't have the corpus behind it that it was trained on. But if you're Westlaw or Lexis or VLEX, you've got the cases, you have treatises, you can use retrieval augmented generation to draft a memo based on what was retrieved. You can look it up in a database. There's still some hallucinations. You know what? Associates make mistakes when they draft memos too, right? So kind of like figuring that out, how to make that work. I think we're going to see a little bit of disillusionment about what generative AI can do in the next couple of years, and maybe we're already starting to see that, but it's a very capable tool. And even more importantly, if you really understand the problem that you're trying to solve, you can use other techniques like looking up information in a database or using a rules-driven system or having a knowledge graph to back up the system that you're building. So I think we're going to see amazing breakthroughs in 3, 5, 10 years. There's some stuff happening now. Some of it's pretty interesting. Just even thinking about the legal research part of it, drafting legal papers or analyzing different legal papers, not even just summarizing them. There are people that are, in addition to that, working on structuring the data, taking a complaint, pulling it all out and creating a list of, these are all the legal claims. These are the factual claims. Here's some case law you should look into to look at those legal claims. Oh, here's some fact discovery you should do in this case. Producing a report like that in 10 minutes, that would have taken an attorney 10, 20, 30 hours probably to produce. So this is going to really change the way we practice, and it's really gives us amazing capabilities to build tools for self-help as well.
I'll give my own example of a potential use of generative AI. Margaret mentioned the facility of generative AI in plain language. I think the clarity of communication that comes out of generative AI is, in terms of communicating with people who don't have lawyers, is better than lawyers can prepare on their own. Lawyers are not good at explaining things to people who aren't lawyers. I live in Washington, D.C. We have about 40 legal services providers here in the District of Columbia, serving a population of about 700,000 people. That's a lot of legal services providers. Every one of them has prepared their own self-help tools, and they're often duplicative. Everybody's got their eviction materials and their protection order materials. You can use generative AI to pull all of this material together. This is curated material. It's all been prepared by lawyers. You know it's reliable. And to come up with a one-stop resource that combines the best of it and puts it in language that people can understand. Generative AI produces information with bullet points and numbered paragraphs. It's very logically presented. It avoids legalese. That, I think, would be a real asset to the community here that needs access to self-help tools they can use. So one question, another question in the Q&A I want to get to. We've talked about the resource asymmetry between the for-profit sector and the legal aid sector. The legal aid sector can't afford some of these tools that have high subscription fees. So if they use something like GPT 4.0, which I believe is available now free to everybody as of last week, does using a tool like that, as opposed to the paid tools that a big law firm is using, create confidentiality or ethics issues? And if so, how can they manage them?
I'll jump in briefly, and then Gabe, you might have something to add to that. But I think that it's a really important question. And when you use the paid versions of the tools, you have more options to protect your data and make sure the settings are set up in a way that you can virtually eliminate these privacy and confidentiality issues. It's not much different than using a trusted cloud provider and storing your documents there. But you absolutely have to be aware of it. And for some of the free versions early on, ChatGPT, the settings are set up in a way that, yeah, that was a big risk. I think even in the free versions of these now, you have a fair bit of control that you can adjust this. To this point about resources, I think it's really interesting because I think that there's also many examples of where the cost of these tools is going to continue to come down, and in a lot of ways, smaller law firms and nonprofits are going to have access to amazingly powerful tools. Now, the other resources that you need to be able to do this is maybe where it starts becoming difficult. Like if you have the talent on your team to set up these environments and things like that. Because another example in many law firms, what they're doing is setting up private instances of ChatGPT using like Microsoft Azure or something like that. And that's kind of like the best case scenario where you have the best protection for confidentiality and privacy, things like that. But again, there are ways to use even the free versions of the tools that are pretty secure at this point.
Yeah, I have to say that in some off-the-record conversations with legal aid lawyers, they have been exploring the free, it's amazingly free tools like Google Gemini and the free versions of GPT, and seeing kind of if, like, not obviously using any confidential data, but figuring out how to make it work for their workflow, where there's value, where there's not. It's never going to be as seamless, quick, and burden-free as it's probably going to be in a corporate environment where they can have these localized, special instances that are like curated and made specifically for the law firm. Hopefully we'll get there, and that we'll have more of that in the public interest space as well, whether that's legal aid groups working together across states to kind of help support more of this kind of public interest innovation. I don't think it's going to be one legal aid org that, like, one law firm can build, a lot of AI capacity, but we might imagine a more networked approach. And then legal aids could have some of that benefit that a big law firm in their AI setup has.
Can you say more about that, Margaret? I perceive a great need for educating in the legal aid community. There's a hunger for information, and it's not great tools to communicate broadly with the legal aid community to answer questions like the ones we're getting in the Q&A here. What are your thoughts on the most effective ways of disseminating information that allows the legal aid community to get up to speed on what's going on out there and what they can use comfortably?
Well, I think obviously there's our wonderful annual conferences. So the LSC Innovations in Technology Conference, end of January, beginning of February. I know we had rooms of 300 plus for AI and A2J. Same thing with Equal Justice Conference, Self-Represented Litigation Network. We have these wonderful conferences where folks from across the public interest sectors are getting together in big conference rooms and getting kind of a taste of it. Unfortunately, I think often that's kind of a temporary reprieve from their day-to-day when they have to do so much client-facing work, reporting work, other kind of need to be done tasks that they don't often get the time to do this more strategic work. And their organizations don't have big staffs dedicated to innovation, AI, technology, as more and more law firms do. That's why I was thinking about a networked approach, so that even if a single legal aid group has one or two staff who can kind of do this technological strategic work, data work, AI work, maybe they can be working, like those in Oklahoma can be talking to people in Michigan, talking to people in Tennessee, Florida, California, find where a common solution or even a common vendor could be benefiting all of them. And whether it's through the LSC's TIG funding or through SJI funding or other kinds of national funding pools, kind of common resources could be developed that benefit many organizations rather than just one.
There's another question in the Q&A. Should there be mandatory disclosure of the use of AI to clients, courts, opposing parties, and others?
I would say no. And I've been grappling with this question talking with a lot of judges about this and some of the standing orders. But I think the first question to ask really is why? Why would there be disclosure? If you're worried about hallucinations, well, I don't think that's going to solve the problem. Judges can use technology, though, to help them review briefs and make sure there aren't hallucinated cases in briefs. That's a solution to the problem. One other issue around this is maybe you're concerned that if you're involved in a legal proceeding, there's a confidentiality and order in place, and you're concerned about how documents you may have produced the other side are going to be used. I mean, there's an obligation there. If there's a confidentiality order in place already, then someone needs to be careful about where they may put those documents. So if they were to load them into a generative AI system that they don't have sound confidentiality preservation, that could potentially be a problem. But I mean, I think we just really have to ask carefully, like, what's the problem we're trying to solve? And I think more and more there's been a fair bit of criticism of these judges with their standing orders, which will have a chilling effect on using these tools. So yeah, I disfavor completely disclosure, and I think it creates the incorrect environment, and I think it creates a lot more problems. It's you can't govern it, whether people are actually complying, and I don't know that it actually solves any specific problems.
We've been focusing on the use of generative AI to improve access to justice. Let's talk more broadly about other kinds of technology and other forms of innovation that can improve access to justice. Dan, you referred to a few earlier. Can all of you offer some additional examples of the use of technology, of innovative approaches to service delivery that you think have the potential to make a meaningful difference in improving access to justice?
I'm happy to take a go at that. One that I've long been intrigued by is document assembly and document automation. So, LegalZoom has shown that this can work for mid-market customers, but the question is, can these sorts of tools be used in the access to justice pro se litigant space? And Law Help Interactive and other organizations have long done wonderful work using lawyers' expertise to build guided interviews where people answer questions and they get a form spit out at the back end of it. And that's the primary work of the Legal Innovation and Technology Lab at Suffolk Law. We've done a triage process where we've taken dozens and dozens of court forms and created guided interviews so that people from their home or their iPhone can fill out the forms, get appropriate guidance, get some of the questions answered, and then get something that is suitable to be filed in court. It's relatively old technology, and by relatively, I mean 20, 30, 40 years. And also, there's really, really good open source technology. So I know that people in the access to justice space are often concerned about the price of we use docassemble.org, which is a free and open source project. Our work is open source and people can build upon that. And that's really, really exciting. And then let me say one other thing that might be a little less obvious. I think we should think about the innovation method of process improvement, borrowed from engineering, Lean, and Six Sigma, as one of the fundamental tenets that we should teach. Creating a workflow about what needs to change and how best to change it is really a skill, and it's a skill that can be taught and learned. And if more people had an understanding about how to do that type of change management, you identify a problem, and then you work out a methodology for how to improve upon it, the world would be a better place, and access to justice would be more effective. So document assembly and process improvement, legal project management are my two.
Let me follow up about document assembly. TurboTax for law, in short. The problem that I've seen, the challenge I've seen with it, is scaling it. Most of the legal issues that affect individual people, and not just low-income people, but everybody, are matters of state law. And you run into our problem of federalism when you try to create document assembly application. You create a document assembly tool, and it works for one kind of case in one jurisdiction. And you've got to do it 50 times over. And sometimes more than that in states that don't have unified court systems, where you have different forms in different counties in the state, and sometimes even different forms in different courtrooms in the same courthouse. So is there a way that generative AI can help to expedite the development of document assembly tools to try to mitigate this problem of replication and scaling that we've seen so far?
Yes. So this is actually the one active implementation of generative AI that the Legal Innovation and Technology Lab at Suffolk is using. So we create guided interviews to handle jurisdictionally specific legal problems. So someone is fighting eviction in Massachusetts, and there's a few different forms, and we use a team of students to create those forms. Now, as you said, Jim, what happens when the person from Rhode Island calls up and says, how do I do that? Our forms look a little bit different. Well, one of our staff members, Quentin Stainhouse, created a tool called the Weaver. And what the Weaver allows you to do is to take the Massachusetts form and the guided interview, and then upload the parallel Rhode Island form. And what it does is it effectively identifies all of the matching variables, drops them into the document for you, and then creates a first draft that does, depending on the situation, anywhere from 80 to 99% of the work. So actually, we had this sort of magical moment at a conference last year where Quentin unleashed this project and introduced it to the audience and asked people to open up their laptops and said, choose a jurisdiction. I want you to use Weaver to create this form for your jurisdiction. And sure enough, within 10 or 15 minutes, we had created a state-by-state version of that. We did a 50-state survey in real time that came up with real answers. Now, those are first drafts, so it would take a little bit more work, but that's the sort of thing that is largely dull to the outside world, but to people like us, it's sort of magical, and we want to do more of it, and generative AI enables that.
I love that.
I'd like to jump in on this real quick, Jim, because I so appreciate the work that Gabe and his colleagues are doing on document assembly and this. I see this as kind of the blocking and tackling, and I've been fighting this fight, I feel like, for over 10 years, where when I've been talking about the need to develop rules-based systems and that we need a knowledge base and we need knowledge graphs and things like that, I think this is what's going to be part of the trough of disillusionment with generative AI, that we're going to see some tools kind of get us tantalizingly close, but they're not deterministic. They're predictive tools. We're going to see that in some areas, the error rates are too high, and that we need kind of these knowledge-driven approaches. Another example I'd give is my colleague at Northwestern, Sarah Losky. She's working with Microsoft. They created a programming language for law. It's called Catala. It's for reasoning about tax problems. Different jurisdictions, including France, are implementing this. And that's just an example where we can really take these approaches and understand as a discipline, what do we do? How do we solve these problems? And in what areas is a more formalized kind of rules-driven approach actually work better versus these probabilistic machines, which in a lot of ways, and this also ties to this innovation and engineering approach, these AI tools are going to force us to start asking questions about quality. And when you've got 5 different lawyers or 10 different lawyers doing it 10 different ways, it's going to really come to light. And they're all going to be saying different things are wrong with the AI version that is produced. And it's going to force us to standardize and come up with better metrics for quality. That'll make it easier to develop AI tools that work. It'll make it easier to build rules-driven and form-building solutions that work as well.
Margaret, can you weigh in, and can you talk about the Forms Fairness Project? Do I have the name right?
Filing Fairness Project, yes.
Fairness.
Yeah, because everything that Gabe and Dan said, I do think that getting the ability for more people to be able to fill in forms and other legal paperwork like fee waivers and affidavits and all of these tasks that you have to do to defend yourself in a case or get through a justice matter is so crucial. And those kind of interactive tools for some part of the population that have that kind of technology and language capability could provide so much more service that people are just otherwise not able to get right now. I'll even go like further back in the technology wheelhouse to like, let's say 2005, 2006. I'm going to say websites, hotlines, and maybe text message reminders. I've been on the ground in Los Angeles courts doing interviews with folks in the hallways who are waiting in front of the court help center or outside the eviction courtrooms. And we've been interviewing them about what technology tools they've used, what's worked well, what they wish they could have used. And so many people, even people who you would think, they only have a mobile phone, they don't have a computer set up at home, they are all starting at Google. When they have a problem crop up in their life, they are going on the internet, they are looking at websites, they're trying to get, who can help me? What are the services? And give me some referrals. What are the forms I need to fill out? Even if I'm not going to fill them out on my phone, at least help me get kind of acquainted with them and ready for this legal process. And what should I expect? What is this court process or this legal problem journey going to be like? they want that kind of basic informational orientation, service referrals, form information on websites. And I'm sad to say that that doesn't often show up on Google search or even on kind of .gov court websites or legal aid websites. So even though we have, like, almost every court and legal aid group has a website, there is so much kind of basic tech that we could be getting better so that everyone who is Googling and searching, and also what the AI tools are learning from and going to be showing people as they ask Google Gemini or ChatGPT, that kind of doing a better job of having really strong, up-to-date, thorough websites can kind of create a lot of help out there with like very low stakes, very low kind of tech requirements. And just kind of hotlines. People really want customer service and customer support from legal aid, from courts. They need that kind of human help to do a lot of these legal tasks. Same thing with text message reminders about when and where to go for their court appointment or legal aid meeting. So even if we think about these as not, the big new hype machine of AI, they can offer a lot of benefit and keep people participating in their legal cases. So I'm a big believer of like the retro technology having like a big impact in getting that right, in addition to the really exciting new AI projects.
Final round of questions, one question, final round. This will need to be a lightning round. We're running out of time. Give us your predictions on the future of legal education in technology and innovation to improve access to justice. What do you see as the barriers to innovation and change in legal education, and what can we do to ameliorate them?
I'm happy to go first.
Go ahead, Gabe.
I think without change, you'll see a two-tier system. You'll see a subset of schools that go all the way in and get really, really dedicated to these things, including the schools that you're hearing about today, and a number of schools that ignore it for as long as they can. I think that's wrong, and that's not the approach that I'd take. I would adjust it in three different ways. One, the ABA, which sets out accreditation rules for law schools, can implement rules and say you must offer training in these areas. We've done it in important areas, including prospectus menu courses, DEI courses. We should do it, in my view, in legal innovation and technology too. It should be a requirement for all law schools. Two, Dan mentioned his colleague, Sarah Losky, who does a wonderful service every year. She breaks down law school hiring. In 2023-2024 hiring cycle, there were 0 new law professors that were hired to teach hands-on legal innovation and technology. Same with the year before, same with the year before that. As a matter of fact, there has never been a tenure track entry-level hire in legal innovation and technology. So this bridges into my third comment. If you're a dean, if you are a professor, if you're a judge, or if you are a law firm partner, this is your opportunity to make this difference. If you're in a position to give money, when you call the law school, think about attaching it to endowing a position for someone to teach hands-on legal innovation and technology. That's the way to make a difference. People have to adjust the status quo if they want a different outcome in the end.
You should be in development, Gabe. Dan?
Yeah, that was a heck of a stump speech. Yeah, those are great ideas. And one of the other things I've been trying to do is get students more engaged. This is important. You're paying the tuition money. You should make your voice heard. This is really important in your career, and you should be demanding that you get this as part of your law school education. And I know employers, because I talk to them a lot, are talking about that this is important and they expect things to change. Please talk to the deans, talk to the people in the law school, and tell them that this is important when you're doing hiring. And so I think April Dawson and I put together an AI and law professors group. We thought we'd get maybe 40 or 50 people, and it's like way north of 100 now who've signed up. So there's more and more interest. I think the other piece about scholarship is important here, because this is becoming, people are recognize the importance and the impact in this space. We're seeing more and more scholarship. If you're a junior, if you're on the tenure track faculty, right, there needs to be a scholarship path. And I think we see that developing as well. And that scholarship can be done so it has a big impact in the world as well. So I think, I'm worried about that things will take too long to develop, but I also think there's a variety of forces that are causing change, and there's more interest, and I think we'll see more change in the near term than we've seen ever before.
Well, I'll go last with my prediction. So I think in the next few years, we'll see kind of a new 1L track that is about technology, AI, whether that's about literacy, responsibility, understanding the school's policies around it, but then also kind of familiarity with the specific programs and use cases that the employers are so concerned about. So I'm guessing that will be a kind of entry-level track that all 1Ls will have to, within their school, take. And I also think that we're going to see a lot more of these interesting clinical policy lab, design lab, innovation lab kind of classes, because I do think universities can play a great role as an incubator of new projects, especially with public interest partners, that universities partnered with them can help them scope projects, do demonstrations, do research of what works, and kind of really be of great value to our legal aid and court partners in helping them accelerate innovation. So hopefully we'll see a lot more of that kind of coursework as well.
You three are all rock stars. This was a wonderful program. A lot of great information, helpful information. Joey, I think there are some inquiries in the Q&A about how to get more information or contact people.
Yeah, there was a question in the Q&A. We will connect the people who've got some questions for the Q&A to our respective panelists and get you in touch with each other. I want to thank our panelists today for such an engaging conversation. There were moments where I had to remind myself to check back in on the Q&A because I was so intent on listening. It's always a pleasure to speak with you, and a big thank you to our moderator, Jim Sandman, for putting this event together. Our AI task force webinars are all available at .org/AI law. You can find all 13 webinars in our event to this date. And of course, this will be our featured event, which will be going live next week on the website on Tuesday, May 28th. So if you weren't able to attend today or you have colleagues you'd like to show it to, it will be available on demand on the ABA AI Task Force website for no charge on Tuesday, the 28th. Thank you all again, and have a wonderful afternoon.